Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Good afternoon, Your Honor. Daniel M. something? Yeah, it's Mr. MKU. And from the jump, this man's already setting himself up for disaster. The judge wastes no time. She tells him straight. He's in court for resisting and obstructing a police officer.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
But do people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant is prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
And continue.
which, in Michigan, isn't just some slap on the wrist. It's a high court misdemeanor, basically a felony, punishable by up to 2 years in jail and a $2,000 fine. And then comes the kicker. The judge lays it out crystal clear. You're representing yourself, and I'm going to treat you the same as a trained attorney. No favors, no shortcuts, no special treatment. Now that's where most people would take a deep breath and realize maybe, just maybe, it's time to hire a lawyer. But not Daniel. No, he's chewing gum in court, literally standing before a judge, facing possible jail time, chewing gum. The judge even stops mid-sentence. You need to remove the gum from your mouth. And you can almost hear the frustration in her voice. See, this guy's been here before. In fact, this is part 2 of his legal circus. The first time, he acted like he was smarter than everyone in the room. Smug, arrogant, like the rules didn't apply to him. And here we are again. Now you'd think someone facing serious charges might come prepared. Instead, Daniel strolls in like he's attending open mic night. The judge asks what we're doing with the case, and he stumbles out something about moving for evident hearing preliminary examination. Yeah, that's what he said. Even the prosecutor looks confused. The state's attorney steps in politely but firmly, saying they can try to move forward. But there's a problem. Apparently, Daniel filed some kind of writ of mandamus with the Michigan Court of Appeals. He's accusing the prosecutor's office of hiding evidence and violating their Brady obligations, which is serious stuff, if it were true. But here's the twist. That appeal was already dismissed. The court threw it out, yet Daniel's still bringing it up like it means something. At this point, the prosecutor basically says, Your Honor, we've given him everything. He's just making stuff up. And honestly, they're right. Daniel's argument is all over the place. He starts rambling about how there's no exculpatory evidence, meaning no proof that he's innocent, which isn't how discovery even works. The judge finally cuts him off. I'm going to indicate discovery is complete because what you're saying doesn't make any sense. Ouch. You could almost feel the silence in the courtroom after that one. But Daniel doesn't stop. He keeps insisting he's ready to move forward, still representing himself, still with no clue what's actually happening. The judge finally sets the next hearing date, January 2nd, 2025. And as he leaves, you can tell the judge is just done. This man is the walking definition of why you hire an attorney. He's facing a felony, talking in circles, chewing gum like he's in a movie theater. I mean, seriously, what did he think was going to happen? So here's where things really start to sink in, and not in a good way for Daniel. You see, this guy isn't just clueless, he's cocky. He genuinely believes he's outsmarting the system, like he's the main character in some courtroom drama. But in reality, he's the one digging his own grave with every word. The prosecutor and judge are trying to keep things civil, but you can feel the tension in the room. Every time Daniel opens his mouth, it's another reminder of how not to act in court. His tone, smug, his body language, defensive. His logic, nowhere to be found. And let's talk about this whole representing yourself thing. People think it's empowering, that it'll somehow make them look confident or innocent. But in truth, it's like walking into a gunfight with a water balloon. The legal system isn't built for amateurs. And Daniel's performance proves exactly why. He's tossing around legal phrases he doesn't understand. Discovery, exculpatory evidence, Brady obligations. Like he's trying to impress someone. But the judge isn't impressed. She's irritated. She's watching a man self-destruct in real time, and all she can do is keep it professional. Then there's the bigger picture. Daniel's not just in trouble for resisting an officer. He's also lost custody of his child over it. That's not something that happens for no reason. The court doesn't just take your kid away because of a misunderstanding. This man's behavior has real consequences, and he's treating it like a debate club meeting. And the saddest part? He still doesn't get it. He walks out of that courtroom with his head held high, probably thinking he handled the judge. But everyone watching, the judge, the prosecutor, even people online, can see it for what it really is. A train wreck in slow motion. He's not clever. He's not in control. He's just another self-proclaimed legal genius setting himself up for failure. You know, I've covered a lot of these cases, from sovereign citizens to delusional defendants, And there's one thing they all have in common. They mistake arrogance for intelligence. They think they're exposing the system, but in reality, they're exposing themselves. Daniel MKU is no different. He's standing in front of a judge, facing jail time, having already lost custody of his child, and still refuses to humble himself. And honestly, it's hard to feel sympathy at this point. This isn't confidence. It's chaos disguised as self-representation. Now, the judge set his next appearance for January 2nd, and something tells me it's not going to go well. The patience in that courtroom is wearing thin, and if he shows up with the same attitude, he's in for a rude awakening. So yeah, this case, far from over. But one thing's for sure, Daniel's about to find out the hard way that representing yourself might sound brave. Until you're standing there alone, staring down a judge who's already heard enough. If you found this one unbelievable, wait until you see what happens in that next hearing. Because something tells me the next time Daniel walks into that courtroom, the gloves are coming off.